All right, well, good morning, everybody, and thank you very much for joining us for our Guildhall Chambers Court of Protection Statutory Wills webinar. It's really great to see so many people signing up to attend this, and at Guildhall we like to think we've got a growing court of protection offering, and statutory wills I think is a really interesting area within that. So it's nice to see so many people wanting to hear a bit more about that. Just to introduce myself, I'm Oliver Mitchell. I come to court of protection from the background of property and estates and probate practice. So I look at court of protection effectively from a probate and trusts perspective, and I think it's easy to see from that perspective how statutory wills is a really interesting crossover area effectively between what you might think of as pure court of protection issues, and of course the issues that arise following somebody's death, and some of the problems that we see playing out when the way that someone's dealt with their estate has not been sorted out as well as it might have been. So as I say, I think it's a really interesting intersection area, and hopefully some of you agree. Joining me today is Ollie Murrell, who is one of our newest additions as a member of Chambers, having not that long ago put up with a year of being my pupil, but he's come through that despite my efforts, and he is busy developing a really interesting specialist caseload. I am going to start things off by talking a little bit about what statutory wills are. I appreciate that that a lot of you will already well and truly know that, a little bit about some of the circumstances in which they might be helpful, and then just a quick canter through some of the procedure. And of course, I'm not going to do that all in exhaustive detail, because we'd be here all morning and I might make you miss your lunch. And then I'm going to hand over to Ollie, who's going to talk us through a bit about how the court actually might be expected to approach a statutory wills application, and some of the specific points that he's going to pick up on. When we've finished with that, we should hopefully have a bit of time for some questions before we finish. So if you do have any questions, then you should be able to put those in the chat. Just a reminder, of course, just to remember that that is a chat that everybody can see, and just please remember not to put any specific details about specific cases or anything confidential in there. And then if there are any questions, we can see about those, hopefully some of those at the end. I wanted to start really today with a premise, which is a situation that those of us who do probate and wills work will probably be very familiar with. And it's the situation that comes up when somebody has died and has left an unsatisfactory testamentary position behind. And of course, you could say, well, Oliver, that's just describing contentious probate work and wills disputes in general, and maybe it is. But we often see, and I'm sure I'm not alone in saying that, situations where a will has failed to provide for somebody, and maybe there's a claim under the Inheritance Provision for Family Independence Act, the 1975 Act arising out of that, or a will has been out of date, or there's some other problem with what it contains, or of course cases where there are issues with the validity of a will, or where there isn't a will at all, and that's a problem. And of course, it's effectively axiomatic with probate and with wills disputes that where you are dealing with a situation, as you typically are, where the testator is dead, there is no good way of sorting those issues out a lot of the time. Sometimes you might be able to rectify a will or whatever it is, or come, some agreement might be possible. But ultimately, you are often sort of trying to close a stable door after the horse has bolted, because you already have a will or a lack of a will that's causing a problem. Beforehand, of course, it may be that the problem doesn't come to light. And if that's the case, well, if nobody knows, appreciates that there's going to be a problem, then it may be that it's not readily fixable. But it may be that it is known that the lack of a will is going to be a problem, or that the will that there is going to be a problem at a time when the testator is still alive. And of course, if the testator is alive and has capacity, then it shouldn't be too difficult for them to fix that if they've got the will to do so, that is, rather than the will as a document. But there's an intermediate situation where somebody has lost capacity, but where it is known that there is going to be a problem arising over the will or over the intestacy. And that is a situation where the statutory wills regime exists potentially to step in and deal with the problem at a time when a new will can be made. And essentially, that is what statutory wills are all about. And that's what I'm going to start by hopefully having a bit of a look at, if I can progress the slides. There we go. So what is a statutory will? Well, of course, the standard advice that is given out to capacitous clients by solicitors is if your circumstances change, consider whether your will needs to change or whether you need a will. And a statutory will is, on one level, simply a will which is executed on the authority of the Court of Protection for someone who lacks capacity. And just for those who maybe aren't familiar, in the world of Court of Protection, the person who lacks capacity and is the subject of the Court of Protection proceedings is referred to as P. So I'll be using the term P, and that's what I mean by that. And it's quite an odd power in many respects, because you are asking a court to make a will for somebody. It feels quite strange, but we can see that it could be an important power that the court has, because it might allow you, in the right circumstances, to avoid a problem that's coming down the line. It's obvious that it shouldn't be something that you seek to do casually. I mean, generally speaking, we as lawyers are not going to encourage people to litigate casually anyway, and I don't think anyone would suggest that statutory wills are a place to depart from that. But it is I would suggest, an option that should be considered if it's apparent that there is a potential issue arising over a will, because it could be really regrettable if in due course P dies and there is a big problem that then can't be readily addressed, and anyone saying, if only we'd been able to do something beforehand. This may be the opportunity. What's the basis for statutory wills? Well, it comes as one might think do most things in the modern world of the Court of Protection, from the Mental Capacity Act 2005, and specifically the power under section 16(2), which is the power of the court to effectively make decisions, and expressly section 18(1) little 1 extends that to the execution of a will. So that's where the power comes from. It's important to note that in this respect, P has to be at least 18. So this is not something that can be done before P hits 18. It's also, just to be clear, not something that is open to a deputy to do in terms of making the decision to make a new will for P and executing a new will for P without the court having made an order. Of course, as many of you will appreciate, the court essentially has two routes for a lot of its decision making, which is one, to make the decision itself, and two, to appoint a deputy and give the deputy the power to make that decision. It is expressly not open to the court to appoint a deputy with the power to make a will for P. That is a power that is reserved to the court. And if you want a statutory will, even if it's the deputy who wants the statutory will, you have to go to the court and ask specifically. And as is, again, entirely typical of Court of Protection. The court will be guided by the principles in section 1 of the 2005 Act and by the best interests of P, as discussed under section 4. Best interests is a theme which completely is shot through Court of Protection practice, and it applies here too, and Ollie will talk a bit about that in due course. It's worth emphasising that a statutory wills application needs to be framed and needs to be considered in terms of best interests, in the sense that, for example, if you apply the sort of thinking that you might apply under the 1975 Act to an application for a statutory will, and if you take the approach of simply thinking, well, the existing will, for example, is about to do something that seems harsh on my client, that is not going to be enough. It might be that if P's will is not going to be fair to somebody, it might be that that absolutely points to a basis for a statutory will, but effectively a step is being missed out there, because the basis for that statutory will would be that it may be determined to be in the best interests of P to make a will which provides fairly for that person. Simply saying somebody's been missed out here, that's not enough. It has to be framed in terms of it being in P's best interests to make that provision. And it's just worth flagging, I think, that failure to think in those terms, failure to engage with the best interests framework in statutory wills applications, as in so many areas of CoP practice, is likely to potentially be a problem. So why might you potentially consider a statutory will? Of course, there are potentially lots of different circumstances in line with all the different circumstances that P might find him or herself in. But here are a few possibilities. One would be he doesn't have a will and there might be a problem with an intestacy. So what might that problem be? Well, it might be that it's obvious that it's going to result in something which is inappropriate or effectively accidental. So the example I've given here is if P has a partner, by which I mean not someone that P's married to, not someone that P is P's civil partner in a statutory sense, just a partner who has no special legal status, that partner might be about to miss out under an intestacy in favour of some relatives who haven't actually had anything really to do with P and might be quite distant in reality. And it might be thought to be fairly plain that P would have wanted to provide for a partner. And a lot of us will have been in the position of being asked to consider a 1975 Act claim by a partner who has not been provided for in a will. And the footing for that claim will often be that that there should have been such provision, and it might even be suggested that, well, the testator in that case would have wanted to make that provision. And again, this might be a situation where that can be headed off at the pass effectively with a statutory will application. It might be that an intestacy is going to have a fairly arbitrary effect, and in fact, it would be thought that there might be something that P would rather have happen. Another example, the circumstances have changed, the will hasn't. So it might be that it's well known that that P is no longer on speaking terms with the person who's the main beneficiary under the will, and it might be thought that P would no longer want to leave the assets to that person. Maybe that person has done something that would be really readily subject to criticism, and it wouldn't be considered in P's best interests to then benefit that person. Maybe P's a happy circumstance for a statutory will application. Maybe P has won the lottery and there's a load more money to deal with than P ever anticipated. Maybe there are some specific gifts which have effectively gone out of date and need to be updated. Maybe P has formed a new relationship or had children and has failed to update his or her testamentary provision to reflect that. And again, somebody is potentially going to be treated in a way that might seem quite unfair under the will. Or maybe indeed there is a question mark over an existing will, and a useful quote for that comes from His Honour Judge Hodge, QC, as he then was in Read D. And I've put the quote up there on screen. And the basic point is that if you have a situation where there is uncertainty about a will, it may be better to deal with that. It may be better to deal with that by means of a statutory will application, rather than having the huge probate battle that may play out after P has died. So those are some of the reasons why you might think about a statutory will. In essence, you could put it in these terms. Is there a situation where had P had capacity to make a will in the ordinary way, would P have been being advised to consider whether the testamentary provision needed to be updated? If that is advice that you would be giving to a capacitous client, then it raises the question, is it maybe worth at least thinking about a statutory will? The answer might not be to always go for a statutory will, of course, but it's worth at least ticking off the box of having considered it, I would suggest. So how does one actually go about applying for a statutory will? Well, it's a standard Court of Protection application process for a property and affairs matter. It's commenced with a form COP1 and a COP1C, which is a relevant additional form, and the COP1C lists other documents that are needed and other requirements. The permission stage is not applied. It's disapplied, as you can see on screen, it's disapplied once in respect of a deputy, and then it's disapplied anyway, or doubly disapplied for a deputy, by virtue of the fact that it's a property and financial affairs application. So the permission stage is not in play. There is a specific practice direction that deals with statutory wills applications and applications of that sort. It's practice direction 9E. And that includes, for example, consideration that will be given to the participation of P. That's at paragraph 10. That is, in a sense, the usual sort of consideration that you see the court having to give to how P might participate in a property and financial affairs application where it's not necessarily going to be the case that P is a party right from the start. And just a point about case management. A statutory wills application is not allocated to one of the three pathways by default. So that's in practice direction 3B. I should say for those who don't routinely practice in COP, the practice directions sit alongside the 2017 Court of Protection rules. Practice direction 3B, you would ordinarily expect a property and financial affairs application to be allocated and case managed along that pathway. Statutory wills are not, so they don't have a pathway by default. Consideration will need to be given to who is a respondent, and again, the practice direction 9E points out who should be a respondent: existing or proposed beneficiary who is likely to be materially or adversely affected. That's probably a matter of common sense in many respects, but if the statutory will being sought is going to impact on somebody significantly, then they probably need to have a say in proceedings or be given that chance. And likewise, a prospective intestacy beneficiary. So if somebody is about to benefit, if there isn't a will, and you're proposing to have a will made, again, that's going to be someone who needs a chance to play a role. Direction 9E, and I appreciate I'm rattling a bit through a practice direction here, but it's worth flagging these points. Sets out at paragraph 6 a detailed list of what is required to support one of these applications. It is a detailed list. I've set out some of what it includes, but there's really no substitute for actually going and having a careful look at the list if this is a road that you're going down. You can see it includes a draft will, it includes a copy of any existing will. The court is going to need to know the details of the family, quite likely a family tree, assets, income and expenditure, needs and circumstances, the effect of what's being proposed. It also is going to need a medical report on P. It's worth, you don't, I would suggest, want to be in a position where you're making one of these applications and you get in front of the court and actually you haven't considered and pulled together what's needed to make a properly thought out application. So it really is worth engaging with that up front. Because we are talking about something in the court of protection, and it's worth emphasizing because it's an area that feels a bit like probate and 1975 Act claims and things like that. So it's just important to re-emphasize that it is court of protection and the thinking that's required. The implications for P are going to be absolutely central, as is almost always going to be the case in the court of protection. So again, a statutory wills application that is not framed around what this means for P is very likely to be heading in the wrong direction. It's optional to provide details of the circumstances of a proposed beneficiary. I have to say, I struggle to see when that is not going to be relevant, because if you are proposing to benefit somebody and the court doesn't know whether that person is themselves a multimillionaire, it's very difficult to see why a judge is not going to be interested in that question, because obviously whether or not the proposed beneficiaries of the new will actually need to benefit is clearly very likely to impact on what are the best interests of P. Care. This is a point that there is a point that emerges in a detailed and lengthy judgment of Mr. Justice Charles in the case of ADS and DSM. That is a judgment that is arising from a fairly special set of circumstances. I'm not going to try to dive into the full detail of those circumstances, but it flags a point that one really needs to be aware of on these applications, which is that in that case, there had been some existing litigation, some existing chancery litigation between P and one of P's children. That had been settled, and the terms of that settlement included that there was going to be an application for a statutory will, basically splitting assets equally between children. And on that application, a different split was actually advocated on behalf of P, and the first instance Court of Protection judge went with that different split, and that was then that decision was set aside on appeal in front of Mr. Justice Charles, and the basis on which that was dealt with that way by Mr. Justice Charles was effectively that there had been a failure to apply the best interests test, and Ollie will come on to that test. And I think it's right to say the case law has been glossed slightly since has been glossed slightly quite recently. But Mr. Justice Charles was looking at the best interests test, and effectively what he was pointing out was that you need to engage with, if there have been allegations made, because there have been allegations in the chancery proceedings, there needs to be an engagement with to what extent those allegations need to be determined by the Court of Protection on the statutory will application, or to what extent people agree they can just be left floating as allegations. There needs to be engagement with the background circumstances that might shed light on P's expressed wishes and feelings, and there needs to be an engagement with how a chancery settlement is then going to interface with an application for a statutory will. And as I say, some of this goes into quite specialized stuff about what had happened in that case, but the overall thread that I seek to draw from that is how I've summarized it on the screen, that if there is a complex background history, particularly if there are disputed allegations in play, then you really need to give some consideration to making sure that the court has the material available to it, that it is invited to make the necessary decisions, that the parties understand what the court is doing and what arguments the court needs to hear and what evidence it needs to hear and what it has to decide, to be able to actually have the correct background against which to make that principal best interests decision. In very simple terms, if the court is not being invited to ask the right questions on a statutory wills application, then you can't expect it to come out with the right answers. So you really need to think about what does the court need to engage with about the background circumstances, and are there assumptions being made? Are there question marks being left floating that might be a problem? So that's just one to really bear in mind when you are framing up an application and what needs to back it to avoid running into potential trouble, hopefully later. And just one last point from me before I hand over to Ollie. Costs, unfortunately, in the reality of litigation, they're rarely far from people's minds. The general rule, as many of you will know, in Court of Protection Property and Affairs matters, and I need to emphasize property and affairs matters, is that P or P's estate covers the costs of the proceedings. There are really 2 points that come from that. The first is that obviously has the potential to have a very unfortunate effect on P's finances. The Court of Protection is effectively a venue where everybody is supposed to be thinking about P's best interests. So point number 1, I think, is just a caution to remember that if you are litigating about P's best interests in a way that could end up spending a lot of P's money, it's useful for everybody to keep that in mind and just make sure that they are not, in fact, compromising P's best interests too badly through the litigation and through the dispute that might end up costing P a load of money through something that that P never started, so to speak. And the second point arising from that is the court is alive to that. Of course it is, as we all should be. It is a general rule. It does not have to be applied. So if an application is not one that should have been made, if it is pursued in a way that it should not be pursued, you cannot count on the court not disapplying that rule and not making a costs order that your client bears their own costs or that your client bears someone else's costs. So although there is that general rule, it's worth remembering that is not an excuse to burn through a load of money, and the client still needs to be aware that they can't assume that they're safe from ending up paying costs. So that's just a costs warning, much like the cost warnings that often go with civil litigation, but with a specific costs gloss. So with that, I am going to hand over to Ollie, and I am going to attempt to give Ollie control and see if I can get my face to disappear from the slides. So just bear with us for one moment.
Thank you, Oliver. I will now be addressing how the court approaches and determines statutory wills. So by this point, you should have already been through your practice direction, been through the relevant points that Oliver has set out. But before you step into the courtroom, there are a few preliminary points that you may want to consider. The first is capacity, and many of you will be familiar with capacity issues, whether you're probate practitioners or CoP practitioners, but there is an important point to make, and that is they have different tests. The probate test is that set out in Banks and Goodfellow, and the Court of Protection test is that set out in the Mental Capacity Act. They are different, and so that there is a potential that they can produce different outcomes. And this may result in what can be called a grey area, whereby P does not surpass the threshold for a statutory will under the CoP test. But if he made a will, it would be found to be invalid following his death. Now, I can't really envisage a circumstance in which that would happen, but it's at least important to be alert to it, not least so that you don't find yourself in the wrong court talking about the wrong test. The second point is jurisdiction. The Court of Protection has jurisdiction to make a statutory will in respect of a P who is domiciled in England and Wales and immovable property in England and Wales, but a statutory will not be effective against immovable property which is outside England and Wales, and that in the usual circumstances will be the holiday home in Spain or the chateau in France if you have potentially richer clients. However, what can often be forgotten is, for example, the flat in Edinburgh. Scotland has a different capacity jurisdiction, has different tests and courts of its own, so it's important to ensure that you're distinguishing between England and Wales and the United Kingdom. In terms of where P is, the court has jurisdiction to make a statutory will, even if P is domiciled abroad, but only if P's testamentary capacity would be determined in accordance with England and Welsh law under the law of his domicile. The other point which Oliver touched on is underlying disputes. And many of you will be familiar with the lurking proprietary estoppel claim by a son who wants the farm, or as Oliver pointed out, the partner who is not currently entitled to anything under a will, but would have a very good claim under a 1975 Act application or under a constructive trust. The Court of Protection will be very wary of getting involved in those disputes, and it may well refuse to hear a statutory will application at all if there is those disputes going on in the background. Connected to this is the validity of a previous will. This is a good reason for making a statutory will application, but the Court of Protection will not endeavour to determine whether that will is in fact invalid. I doubt whether it has jurisdiction to make such a determination, and my personal view is that it doesn't, and so don't go asking the Court of Protection to do so. On the point of wills, it is important to have a draft one. Have a draft one not only attached to your application, but in circulation well before you're stepping into the courtroom. Make sure it's circulated amongst respondents and that you invite their comments and their views, but also make sure that it's shown to P. It may seem like an obvious step, but P's, as we'll come on to, present wishes and feelings are still relevant. And I've noted there that you should record points of dispute. That may seem like a bit of an obvious point as well, but it can often go missed. Finally, on medical evidence, it is important that you have medical evidence in advance of the hearing, and obviously you will need medical evidence to show that P does in fact lack capacity to make a will. But if you don't have rock solid medical evidence, or indeed much medical evidence at all, don't be deterred from making a statutory will application, because the circumstances in which that can arise are numerous. It might be because P is refusing to engage with a psychiatric evaluation, or it might be that you don't have access to P because he's being isolated and that the statutory will does in fact form part of a wider financial abuse type issue. If we could now move on to how the court determines a statutory will. As Oliver said, P's best interests are critical, and they underscore all of the factors and the circumstances which the court will apply. It is P's best interests that you must always be looking back to and considering, is this provision in P's best interests? Is a statutory will in P's best interests? It's so easy to just look at the factors in section 4 and simply apply those. They are, however, still very important. In particular, the circumstances set out in section 4.6 and section 4.7, and I've set out on the screen in the slides the factors the court must consider, and so far as they're reasonably ascertainable, it has to consider P's past and present wishes and feelings, P's beliefs and values, and other factors which P would be likely to consider if they were able to do so. Particular emphasis is given to relevant written statements made by P when they had capacity. The obvious written statement by P is a previous will. If you do have a previous will, then it seems a perfect place to start when you're then embarking on a statutory will application. If you're, for example, making the application because a main beneficiary has died, then that doesn't affect other specific legacies P may have made in the previous will. If P has left £5,000, for example, to a charity by way of specific legacy, invariably P will have wanted that to have been made regardless of whether the main beneficiary dies or was changed. And so that's an important point to look back to. But as we move forward in the technological age, the importance of social media may well creep into P's past and present wishes and feelings, because that is still a written record potentially of P's beliefs and also his wishes and feelings. And many of you will be familiar of the overzealous tweeter who always talks about how they want to leave certain money to the charity of their choice, or alternatively, the Facebook poster who's always talking about how they never want to leave anything to their great-granddaughter. That will become more relevant as time progresses, and it's important not to overlook the written statements beyond simply a past will. In respect of P's beliefs and values, I think it's most appropriate to highlight the potential issues of following P's beliefs and values to the letter by way of an example. In that case, that provides the best example is Re Meek. In Re Meek, two deputies of P had made significant and ultimately dishonest transfers out of P's accounts by way of gifts partly to themselves, but also to others. And this was an application that formed a broader financial abuse dispute. In the circumstances, His Honour Judge Hodge held that because of P's belief system, which was particularly against dishonest people, as most people's belief system is, His Honour Judge Hodge held it highly influential that P would not have given any money to those deputies, despite the fact they would have been beneficiaries, but for their dishonesty. The other common example that crops up is where P was homophobic and may well have a child who is homosexual. Those circumstances will point towards that child potentially being disinherited, and it may well be that if P had capacity, they would have been disinherited. But as we'll come on to, just because P had a certain belief system and just because it has to be considered does not mean that the court has to give any specific weight to those beliefs and values. The other catch-all circumstance is other factors that P would be likely to consider. Part of this circumstance regards professional advice P might have received and would have taken if he was sat in a solicitor's office drafting a will when he had capacity. The often cited example in this respect is tax mitigation. I find this a slight misnomer, as lots of the case law and commentary focuses on tax mitigation as an example of something which will not be taken to be in P's best interests. But I find it a misnomer because lots of tax mitigation takes place by way of lifetime gifts. And obviously in a statutory will application, we're talking about what happens with P's assets after P dies, and the court is not going to go about dissipating huge sums of P's assets and P's property in order to avoid a bit of inheritance tax. In terms of section 4.7, I've got there on the screen the people who the court must account for, and where appropriate and practicable will consult the views of. They're not just the respondents to the application. They include carers, they include people interested in P's welfare, they include LPAs, and they include deputies. It is important before you launch on your application that you yourself find out what those views are, because it's no good being sat in court before a judge for the first time and only then realizing that P's carers, in fact, consider P shouldn't be making certain gifts to people because he talks about how much he dislikes them all the time. That would be a prime example of why you need to seek out those views and consult with those people before the application is made, so that you know when the court determines the application what those views are. So what is the decision-making process? And you'll have realised His Honour Judge Hodge, now KC, is at the forefront of lots of these authorities and decisions. In Remeek, he set out the basic decision-making process. He states that obviously the touch point is P's best interest, but this is an objective test. And this links to the judicial judgment, not judicial discretion element of the decision-making tree, which I'll come on to. The court is also going to consider all of the circumstances, and whilst it is going to give particular weight to the circumstances in section 4, there may well be circumstances that are not covered by those circumstances and are not covered by the catch-all provision in section 4.6c. There are, however, no hierarchy of factors, and the courts have gone to great length to stress that there will not be one magnetic factor. That said, inevitably, there will be a magnetic factor if P has made, for example, a previous will or has made a rock-solid statement of his wishes and feelings just before he lost capacity. As I said before, P's beliefs and values are also important, but returning to the example of the homophobic parent and the homosexual son, those belief values are not necessarily going to be given weight by the court just because P held those beliefs. A slightly more contentious decision-making element is the view of P having done the right thing. And this is the court's essentially saying that P's best interests don't die with P. It's important to consider how P would have wanted people to think of him after he died. And this is particularly important in respect of people who will not be beneficiaries under a statutory will. Would P be concerned that his great-nephew didn't receive £5,000? Would he be worried about how his great-nephew thought of him? Now, whilst I think that is certainly an influential factor in some cases, the court has moved slightly beyond giving that the weight it previously had done. And in fact, in Reed G, a recent case by Mr. Justice Morgan, his lordship held that there was no weight to be given to that consideration at all, because ultimately P may not care at all about how others think about him. As I said, it's a matter of judicial judgment, not judicial discretion. The court is embarking on an exercise where it's weighing up and balancing various factors going in either direction and then finding where that balance lies. If you start hearing judicial murmurings about discretion, then you may want to begin to consider your appeal processes, but that's beyond the scope of at least my part of the webinar. And I think Oliver's as well. The final practical point is a balance sheet approach. This is an approach encouraged in particular in recent years by senior judges and senior practitioners, and now myself. Form a table where you record the arguments, you record the views of each parties, you record the beneficiaries and you identify them, and you outline in columns or rows what their share will be, what it's been reduced by, what it's been increased by, or how it's come about. In the circumstances of a highly contested statutory wills application, such table can really cut through all of the arguments and cut through to the heart of the case, and at the very least assist a judge and guide them. So turning now to a slightly different point, urgent applications. Urgent applications are where P's death is imminent, and there is some slight difficulties in proving imminence, because the Court of Protection requires unequivocal evidence of P's condition and why the application cannot be made normally. The usual time, or normal time at least at the moment, for an application to be processed is 6 months to a year, and so imminent may not necessarily mean within the next couple of weeks. It may be that imminence is within 2 months to 3 months. But what the court will not allow is a statutory will by way of urgent application without unequivocal medical evidence. Where the imminence is of such degree that you won't be able to go off and get bundles of medical evidence, you won't be able to go off and get a report from a consultant about why P is going to die, say, within the next few days, you should consider a holding will. Holding wills are of a lower standard. They are potentially easier to get, and it may be preferable to get a holding will in circumstances where you can't get hold of the evidence that P is going to die within the next couple of days, weeks, or months. The lower standard there is the usual one for urgent applications under Section 48, and there is a reason to believe that P lacks capacity in relation to the matter. The matter is one to which the Court of Protection powers under the Mental Capacity Act extend, and of course they do, because the court has statutory will powers. And finally, it is in P's best interests to make the order without delay. In circumstances where you have someone with an early diagnosis of dementia, but all of a sudden they take a fall, and there's pretty good reason to believe that they're not going to be waking up from their sleep or their coma, then you may want to rush off and get a holding will. And in those sort of circumstances, you're not going to need that 20-page report from a consultant psychiatric doctor. The diagnosis of dementia will be sufficient to get you over the line. And so holding wills offer an important alternative to the usual urgent statutory will application process. The final point there on the slides is notification requirements. Obviously, in cases of extreme urgency, you're not going to be able to send out first-class post notifications to all of the beneficiaries far and wide. But what you can do, and what you're really encouraged to do, is pick up the phone, text, email, WhatsApp, whatever it may be, to make sure that as many people as possible are notified. The other vital person to notify in that circumstance is the official solicitor, and they will usually be very happy to assist and provide guidance if you're just picking up the phone, because ultimately it is the official solicitor who takes, at least in usual cases, responsibility for P in applications. A final point to really not forget is execution. You've got a statutory will in your hand. What do you now do with it? Well, it must be executed. The first thing that you do is that you get it signed by P, acting by his authorised person. The authorised person then needs to sign it with the name of P and in their own name. That's an important dual step, and it must be done in the presence of 2 witnesses who are present at the time. Those 2 witnesses must then attest and subscribe their name in the presence of the authorised person. The probate practitioners out there will recognise this as the same step for a regular will, and it is the same execution methods for a regular will. That is because a statutory will is still a will. Just because it has been approved by the Court of Protection does not mean that it sits in some special category of will or that it has different rules. Once you've executed the will, you need to send the original statutory will and then 2 copies of it to the Court of Protection. The Court of Protection will seal the will, and it will then return the original, and it will return 1 copy to the applicant. And the final important point to note is that the applicant's solicitor is usually required to hold the will in safe custody for the rest of P's life. It is no good someone going back home with it. Now, that generally covers statutory wills. I hope what Oliver and I have said has been useful. And so if there are any points you would like clarification on, or we can answer, we're very much inviting questions through the chat function.
Well, thank you very much, Ollie, for that. And two things in particular I thought were quite interesting from that. The first being, actually, I think I got my order wrong in terms of Judge Hodge in terms of his gloss. I think, in fact, it looks like the Meek case came before the ADS case. But as Ollie says, it's really interesting to see how one judge can really play quite a significant role in evolving case law. And the other thing that I think is striking, that goes back to my observation that it's a slightly strange jurisdiction, and it feels quite strange, is this notion that while essentially execution looks like a normal will, it's being executed by the authorized person in the name of P and in their own name. And that when you think about it, that's actually quite a strange seeming thing, that someone is signing somebody else's will as sort of as for somebody else and as themselves. It's yes, it has a slightly strange feeling to it. So with that, I will see if I can stop sharing my screen now, and I can see we have a question, which is how will the Court of Protection deal with P who has a mutual will in place? Is it reluctant to put in place a statutory will in this case? I don't know if Ollie, if you know anything specifically, have looked at all specifically about whether there's any case law discussing that question. I mean, it seems to me, and this is without any without the benefit of any authority to hand on the point or any commentary, it seems to me, just as a matter of principle, that the fact of a mutual will is likely to be significant. It may even be just in terms of the fact that there was some specific thinking behind that. But even beyond that, a question that's going to have to be engaged with, and I don't know if I don't have the answer to this. I don't know if Ollie has any thoughts. It is whether or not actually the mutual will can operate as a bar, because of course the issue with mutual wills is that if that there's supposed to be that reciprocity, and in a case where there's been mutual wills, the husband or wife or partner has died, and then P is looking to change that, I can imagine that could be a factor which at least the Court of Protection is going to take account of. But it may raise a question as to whether the Court of Protection is actually properly able to depart from that, because of course it's doing something on behalf of P, and I can well imagine that it may be that if P was debarred from being able to change that will capacitously, it's not immediately obvious to me why the Court of Protection would be able to go further than P could have done him or herself. So I would that's not a question to which I have the answer to hand, but it's a good question, and I can see that it wouldn't be sensible to just assume that the court has the power to do that without looking at it and without thinking what power P would have. I don't know, Ollie, if you have any further thoughts on that, or if you would agree with that.
No, I would agree with that. I've just had a quick search whilst Oliver's talking there, and there doesn't appear to have been any case law so far which considers mutual wills in the statutory wills context. That is in large part because there are so few reported cases regarding statutory wills. My view is that where you have mutual wills and the partner or the spouse has already died, the court is much more likely to entertain a statutory will application than in the reverse circumstances. That's certainly an interesting question, which there may be a reported case on the horizon soon.
And I can see we have another interesting question, which is about medical evidence to show that P lacks testamentary capacity, and is the test the test for the COP3, is it Banks and Goodfellows? So it's the common law test that you would apply for a will in ordinary terms, or is it Mental Capacity Act? And I think I'll turn over to Ollie in a moment because he's talked about that. But I think the important thing to say in respect of that is that there's always going to be a line drawn between does P have capacity to make a will, and does P have capacity for Mental Capacity Act purposes? And I'll just, before I hand over to Ollie, the other question that comes about is the COP1A. The COP1A, you get the COP1A through a slightly circuitous route, which is actually that the COP1 requires for a statutory wills application a COP1C, and the COP1C requires information which comes in the form of the COP1A, or it suggests it might be possible in another form, but effectively probably COP1A by virtue of what's required under the COP1C. So I will hand over to Ollie, and I can see we've got another question about medical evidence, so I'll hand those over to you.
I think Critty has helpfully just slotted into the chat box the answer to the question about Banks and Goodfellow or the MCA. The answer is, broadly speaking, the MCA, the COP3 form, does specifically ask for comment on whether P can understand, retain, use and weigh the relevant information. That is the MCA touchstone, the relevant principles arising from the MCA, whereas Banks and Goodfellow has a slightly different approach. The reality is that there will be so few circumstances where P will have capacity under one but not the other. I wouldn't be too worried about it, but going back to the point of your question, it is the MCA principles which apply. Whilst I'm here, I'll address George's question about the level of medical evidence that would be required for an expedited application. The threshold is very high in respect of urgent statutory will applications. It does require unequivocal medical evidence. Quite what you call unequivocal will depend on the circumstances. You may well need a consultant's report if there's going to be a steady decline in P's mental state or P's physical state due to, for example, a progressive condition. But if you have, for example, P has slipped into a coma, then the medical evidence that they will need, that you will need, will be less so, because of the implications of P having slipped into a coma is quite different to P gradually declining over the space of 2 or 3 months and then dying at the end of that point. The other important consideration there is, if you are in doubt, it may well be worth going for a holding will over an urgent statutory will application.
All right, well, I don't see any more questions. As usual with these things, if you've got any interesting particular issues arising on any cases that you've got that you'd like to talk about, then we're very happy to be contacted in chambers, and whatever your court of protection issues, if you think they might benefit from help from a barrister, then hopefully there'll be someone in our team who might like to give that a shot. So yes, if you've got any further sort of general questions you think might arise from this webinar, then do feel free to get in touch with me, or no doubt with Ollie either. I see he's nodding. But yes, if you've got any cases that you think might benefit from someone in Guildhall having a look, then our clerks, I'm sure, would be very eager to help you match those cases up with somebody suitable. I think that really just leaves me. I can see we're just gone 12:05. So really just leaves me to say thank you again for your time listening. I hope you found that useful. And as I say, any queries about statutory wills that come to mind afterwards, then we'll be very happy to hear from you. So thank you very much, everybody.
Thank you.